It's anything but simple. As an HR manager, it can mean high costs, wasted labor, limited access to data, and the risk of non-compliance, as well as dealing with multiple payroll providers and technologies. This adds up to a big waste of time and money better spent elsewhere. That's where ADP Celergo comes in. It's the all-in-one global payroll solution for mid-size companies with one system of record, one integrated HR connection, one centralized point of contact. ADP Celergo is a unified cloud-based solution that combines global payroll with local expertise, offering assistance in up to 140 countries, including on-the-ground specialists to provide local regulatory compliance advice, and a diverse team representing more than 45 languages. Accuracy for records and reporting with access to consolidated data across all countries. Reliability for data that's protected, secure, and compliant with financial standards across the globe. And efficiency for payroll that's on time, cost-effective, and under control. All overseen by your own dedicated account manager, providing high-quality support for all your payroll needs. ADP Celergo Global Payroll gives you more time to focus on growing your business because we take care of the rest. ADP Celergo, unified payroll for businesses across the globe. Global payroll. It's anything but simple. As an HR manager, it can mean high costs, wasted labor, limited access to data, and the risk of non-compliance, as well as dealing with multiple payroll providers and technologies. This adds up to a big waste of time and money better spent elsewhere. That's where ADP Celergo comes in. It's the all-in-one global payroll solution for mid-size companies with one system of record, one integrated HR connection, one centralized point of contact. ADP Celergo is a unified cloud-based solution that combines global payroll with local expertise, offering assistance in up to 140 countries, including on-the-ground specialists to provide local regulatory compliance advice, and a diverse team representing more than 45 languages. Accuracy for records and reporting with access to consolidated data across all countries. Reliability for data that's protected, secure, and compliant with financial standards across the globe. And efficiency for payroll that's on time, cost-effective, and under control. All overseen by your own dedicated account manager, providing high-quality support for all your payroll needs. ADP Celergo Global Payroll gives you more time to focus on growing your business because we take care of the rest. ADP Celergo, unified payroll for businesses across the globe. Global payroll. It's anything but simple. As an HR manager, it can mean high costs, wasted labor, limited access to data, and the risk of non-compliance, as well as dealing with multiple payroll providers and technologies. This adds up to a big waste of time and money, better spent elsewhere. That's where ADP Celergo comes in. It's the all-in-one global payroll solution for mid-size companies with one system of record, one integrated HR connection, one centralized point of contact. ADP Celergo is a unified cloud-based solution that combines global payroll with local expertise, offering assistance in up to 140 countries, including on-the-ground specialists to provide local regulatory compliance advice, and a diverse team representing more than 45 languages. Accuracy for records and reporting with access to consolidated data across all countries. Reliability for data that's protected, secure, and compliant with financial standards across the globe. And efficiency for payroll that's on time, cost-effective, and under control. All overseen by your own dedicated account manager, providing high-quality support for all your payroll needs. ADP Celergo Global Payroll gives you more time to focus on growing your business because we take care of the rest. ADP Celergo, unified payroll for businesses across the globe. Global payroll. It's anything but simple. As an HR manager, it can mean high costs, wasted labor, limited access to data, and the risk of non-compliance, as well as dealing with multiple payroll providers and technologies. This adds up to a big waste of time and money better spent elsewhere. That's where ADP Celergo comes in. It's the all-in-one global payroll solution for mid-size companies with one system of record, one integrated HR connection, one centralized point of contact. ADP Celergo is a unified cloud-based solution that combines global payroll with local expertise, offering assistance in up to 140 countries, including on-the-ground specialists to provide local regulatory compliance advice, and a diverse team representing more than 45 languages. Accuracy for records and reporting with access to consolidated data across all countries. Reliability for data that's protected, secure, and compliant with financial standards across the globe. And efficiency for payroll that's on time, cost-effective, and under control. All overseen by your own dedicated account manager, providing high-quality support for all your payroll needs. ADP Celergo Global Payroll gives you more time to focus on growing your business because we take care of the rest. ADP Celergo, unified payroll for businesses across the globe.
Shift back to a general community quarantine for the National Capital Region, the number of COVID-19 cases has continued to increase. So just last Friday, the DTI and the DOLE issued supplemental guidelines for the workplace prevention and control of COVID-19. And as part of COVID-19 preventive measures, employees who test positive for the virus are required to quarantine for 14 days or more. So our primary question for today's webinar is what are the obligations of the employer in connection with the wages and benefits of employees who are under quarantine? As we are physically distant due to the quarantine protocols, we are seeing each other in the digital world. So on that note, please bear with us in case of technical difficulties. As we continue to reach out to a wider audience, we are also making our webinar accessible via PMAP's Facebook page and YouTube channel. You can type People Management Association of the Philippines or search for @PMAP 1956. So in case you have questions, you may send it to us using the WebEx chat box, or for those watching on Facebook and YouTube, please post your questions in the comment section. Kindly note that presentation materials are one of the perks of being a PMAP member. So for PMAP members who wish to have a copy of the slides, and for the non-members who wish to be a member of PMAP, kindly send an email to rhea.paragsa@pmap.org.ph. So to formally start this session, let us welcome our partner from ADP, Mr. John Antos, ADP's VP or Vice President for Strategy and Marketing, who will give us the program rationale. Mr. Santos, good afternoon.
Good afternoon, and thank you so much for all the attendees for joining us for this important virtual event. ADP is proud to continue our partnership with PMAP and the payroll and HR communities in the Philippines as one of the world's largest payroll, human resource, and human capital management providers. For today's event, as we focus our efforts to protect not just businesses, but our workforce, the discussion will stem around issues and challenges faced by both employees and employers. And more than ever, it's important that for both the sustainability of our businesses and protection of our workers, that we join hands to really understand and operate in this type of situation. So with our subject matter experts, they will discuss and provide insights as to what policies, company practices should be in place in terms of triage, monitoring, COVID-19 testing, and mandatory quarantine for employees and its implications on business operations, among others.
Thank you, Mr. Antos. So to join us in this PMAP webinar, I am delighted to introduce our subject matter expert and the panelists. Our subject matter expert is one of PMAP's thought leaders in industrial relations and labor matters. He is a well-respected HR practitioner and at the same time a lawyer. So let us give a round of applause to San Miguel Corporation's Labor Relations Manager, Attorney Noel Balsicas. Also joining us is another member of PMAP's Labor Policy Reforms and Industrial Relations Committee, and concurrently the senior partner of Cadiz Tabayoyong and Partners Law Offices, Attorney Randall Tabayoyong. And of course, we have ADP's Vice President for Strategy and Marketing, Mr. John Antos, as our panelist as well. So I'll turn you over to Attorney Noel Balsicas for his presentation. Attorney Noel.
Thank you, Attorney John. Good afternoon, everyone. I'm glad to be invited to share whatever little knowledge we have insofar as the subject matter is concerned. So just to give you sort of a backgrounder, we are now under certain state of mobility. When you say mobility, because our movements are somehow restricted. There have been so many restrictions since I think middle of March, and we are trying to live with the current situation that we have. But if we go back to the origin of all of this, these limitations in our movements, you will notice that sometime in March 8th, the President of the Republic, His Excellency Rodrigo Roa Duterte, promulgated Proclamation number 922, which declared the state of public health emergency throughout the entire country. So, slide please. So, given that declaration, the section 4 of that particular declaration stated that all citizens, residents, tourists, and establishment owners are urged to act within the bounds of law. Next slide. And with the lawful directives and advisories to be issued by government agencies to prevent further transmission of COVID-19 disease. So on this premise, there were several groups that were formed, and most prominent of which is the one that we now call as the IATF, or the Interagency Task Force, which is the one handling all of these matters relating to COVID-19 prevention mitigation. So given this, the protocol, the IATF issued certain guidelines over a period of time, And we have been subjected to several types of movement restrictions, which resulted effectively to the limitation of our workers in terms of reporting for work. Can you move to the next slide, please? We underwent several pieces of quarantine, and the basis of which is the omnibus guidelines issued by the IATF in April 29, which actually define the limitations under the enhanced community quarantine all the way to the general community quarantine. So under that guideline, there were certain restrictions insofar as movement, insofar as work, insofar as business is concerned. There were restrictions that were imposed by government to ensure that the spread of the COVID-19 is also somehow minimized. And other than that, we also have the guideline that was issued sometime February by the Department of Health relative to the home quarantine, mandatory 14-day home quarantine. So for those people under investigation, those people who have been suspected of, having acquired the virus, they're placed under home quarantine by the Department of Health. And they are restricted from moving around or reporting for work. So these two guidelines actually created a situation where workers are unable to run their work. So many of us are not able to report back to work. Only a few were given that opportunity to continue the usual way of reporting to work, which are those in the front lines, the ones that are what they call essential workers, like our merchandisers, for instance, the medical health workers, and those that are, running our utilities like electricity and so on and so forth. But most offices, most establishments, business establishments, if not all, were actually closed and were not allowed to operate under these particular guidelines. So, having said that, um, the employers who were made to report, who were made to continue doing business, required its employees to render work. And then some people were asking, how could that be? I mean, there's a pandemic, there's uncertainty in our environment, and we're putting people under so much stress and exposing them to certain health hazards. But then again, if you ask for a legal basis for that requirement to render work, it's actually provided under our labor code. It's an Article 89. Can you please move to the next slide, please? Article 89, which talks about emergency overtime work. It says, any employee may be required by the employer to perform overtime work in any of the following cases. First of which is actually the one that is that we are in right now. It's when the country is at war or when any national or local emergency has been declared by the National Assembly or the Chief Executive. So, the proclamation that I've earlier mentioned, Proclamation 992, actually is the very proclamation that is cited in this particular provision of the law. And if you take note of the last sentence, the stipulation of the law says, any employee required to render overtime work under this article shall be paid additional compensation required in this chapter. So if one is made to work during the pandemic because you're a frontliner, because you are someone who is required to render work because of the nature of the services that you provide, and you are actually given that go signal or allowance by government, then you are supposed to receive payment. So what kind of payments are supposed to be received by someone who goes to work? So many questions were asked, and so many people were actually saying that, because of the nature of the job that we're undertaking, because of the situation that we are in, the exposure and everything that we are being subjected to, we should be given more than what we used to receive. This is the contention of most workers. But under the law, if you look at Article 89, while it mentions about overtime work, we have to remember that there can be no overtime work unless, of course, you have the regular work. So under this chapter, you're talking of like the entitlements that a worker who is made to render work under Article 89, kung ano yung matatanggap niya. So next slide, please. Let's try to refresh ourselves. What are the entitlements of workers? One, minimum wage. This is actually the labor standards, no, that is provided by our labor code. So you have minimum wage, holiday pay, premium pay, or when somebody works during a holiday, he gets premium pay, overtime pay, night shift differential, service charges if you are in the service, business, and then you have also paternity leave, parental leave, and so on and so forth, down all the way to the social welfare contributions that are supposed to be remitted by the employer in favor of the employees, such as ECC, PhilHealth, SSS, and Pag-ibig benefits. So if you now consider all of this as the entitlements of a worker during emergency overtime work, then what is the difference between this and the usual work that we do, or the compensation that we receive when we do the usual work? The answer to that is there is really nothing different. What Article 89 provided was essentially saying that you need to be compensated for overtime work if you are made to render overtime work because of a national emergency, such that if someone is made to work during the pandemic, he cannot demand to receive more than what the law provides, or what the policy of the company provides, or what the practice of the company provides, or what has been provided under the collective bargaining. Okay, so all of these things that people are saying that they are supposed to receive during the while working under this current situation is actually more of a wishful thinking rather than a demandable right. But then again, look at the next slide. Article 1711 of the Civil Code actually provides an additional compensation. It says, owners of enterprises and other employers are obliged to pay compensation for death or injuries of their laborers, workmen, mechanics, or other employees if the death or personal injury arose out of the course of the employment. So kung work-related, if the injury is work-related or was brought about by reason of the work, then the employer is supposed to provide additional compensation. Additionally, the employer is also liable for compensation if the employee contracts any illness or disease caused by such employment or as a result of the nature of the employment. Now, this may be something tricky because people will say that, I contracted the virus from work, and actually some government, some LGUs are even saying that, the virus was contracted at work. There is really no basis for any claim of that nature. Why? Because the virus is everywhere. Those who are in the hospital setting may be able to cite this as a reason for them to get additional compensation. No question. But insofar as other work not related to health services is concerned, it's quite difficult to pinpoint that the cause of the illness was actually the nature of the job or was actually acquired while at the job. Because remember, you spend 8 hours at work, yet you spend more hours with other people or with the rest of the environment. So if you have 24 hours in a day, 16 hours of which is not within company premises. What is only within company premises is the 8 hours that you render. And you cannot pinpoint that 8-hour period as the source of the illness that you may have acquired. So that's the reason why this one may be applicable to those who can pinpoint or who's in the business of health services, because we have now a pandemic, and they can actually claim additional compensation. They can establish that the cause of that illness was the nature of their job or the work environment that they're in, but not necessarily the one that are in the usual, I mean, the usual businesses that we have other than health services. Now, so what is really the point here? The point here is, if you are under quarantine and you're not made to work, you cannot ask any compensation from your employer. Let's go to the next slide. In this case of Coca-Cola bottlers versus Iloilo Coca-Cola Plant Employees Labor Union, this is a 2018 case. The Supreme Court said, if there is no work performed by the employee, there can be no wage. Where the employee's failure to work was occasioned neither by his abandonment nor by termination, the burden of economic loss is not rightfully shifted to the employer. Each party must bear his own loss. In other words, where the employee is willing and able to work and is not illegally prevented from doing so, no wage is due to him. Meaning to say, if an employee, much as he wants to go to work, but there can be no work because there is no business there is no enterprise that is open, the business is closed, then the employee cannot demand that he get paid for it, says the Supreme Court. To hold otherwise would be to grant the employee that which he did not earn at the prejudice of the employer. In other words, people who are under quarantine can only demand payment of wages or additional compensation, if that is the case, if and when it can be established that the cause of their sickness or their illness or the prevention of work is actually related to the business that they are, the job that they're performing. Okay? But if and when you are just, the regular, say, factory worker or regular office personnel who is not in the medical services, it's very difficult again to establish and pinpoint your workplace as the source of your infection or the cause of your acquiring the virus. That is why compensation cannot. But then again, we were able to get some sort of ideas on how to continue doing the work, even if, for instance, there is no physical presence in the office. So the Department of Labor and Employment came out with a suggestion of what they call as alternative working arrangements. But if you look at the acronym AWA, alternative working arrangement, it's really a flexible working arrangement. So there were so many combinations, like, there can be, what do you call this, limited work time. And among the most, most prominent of these alternative working arrangements that were suggested by the Department of Labor was the one is called work from home arrangement. So let's go now to the next slide, please. The work from home arrangement is something that is when an employee is made to render work away from his office, as if he's doing the same work that he's doing in the workplace. So there are some reasons, there are some issues there that are associated with work from home, because this is, well, we have the Telecommuting Act, or the law on telecommuting that has been in place, and the IR, of which a department order that was issued in that regard. The acceptability of work from home is not as much as it is in other countries. So many employers were trying to grapple with the idea of work from home from the context of the Telecommuting Act. But now came this pandemic, wherein businesses also wanted to have some sort of sense of normalcy in their operations. Yet they are limited in the sense that they have also some problem so far as movement of people is concerned, they adopted this work from home arrangement. Now, some companies are saying or asking, some executives are asking, uh, can the income or the salary of people who are under work from home be reduced? Because they're not doing actually the things that they're supposed to do. There are certain grounds or reasons for this suggested reduction in the salary, one of which is the lack of visual supervision. So the employee can be doing something else while at work. Employees also able to do personal, extracurricular, and non-work related activities. And real-time monitoring system is not really in place because so many companies adopted work from home only when the pandemic or the ECQ was declared way back in March 16. So um, the, 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 the rationalization of work from home is something that is quite different from the rationalization of the Telecommuting Act. So let's go now to the next slide. So the reasons behind work from home is one, this is an adoption of a flexible work arrangement espoused by the Department of Labor or that of the telecommuting law, but is not covered by the rules. This is not adoption of the flexible work arrangement or the telecommuting law. No? So this is not covered by the rules issued by the Department of Labor. Why? Remember that this is not envisioned to be a permanent form of flexible work arrangement. The same way that the Department Order number 20 of 2009 was issued. This is not also an adoption of the telecommuting law, which is RA 11165 or the DO that implements it, which is DO 202 series of 2019. So the work from home arrangement here is actually an emergency measure. Some employers are saying that we're doing it to help our workers get by the situation. Kahit paano magkakikita. Others are saying that we're providing the work because we need to do certain jobs, certain activities which can be done off the grid, off the usual visual sight of the supervisors. So another rationalization for the work from home is that it is resorted as a measure to contain the spread of the virus. So this is covered by the issuance of the Department of Labor, Labor Advisory number 9, and then Labor Advisory 11, and also Advisory number 17. And this is also covered by other guidelines like the DTI and DOLE interim guidelines issued in April 30, and the IATF Omnibus Guidelines, implementation of community quarantine issued last May 2020. Also, the work from home that we are using now, there are limitations under the present guidelines in terms of the number of workers that are allowed in the workplace, such that some employers, just to make sure that the people don't go hungry while on quarantine, ECQ or otherwise, they're given certain work that can be done at home. So this is precisely because not everyone can go to the office because of the limitations, the number of people that are allowed to report for work. And then the decision to make everyone to report for work is not at the sole discretion of the employer, given the limitations, the banding level limitations set by the authorities. The decision to make employees work from home is a management prerogative. So this is discretionary, my friends. Remember, the employer can always reduce the arrangement or take back the arrangement or remove the arrangement of work. Why? Because again, this is just an emergency measure. Essentially, there is really no work that can be rendered, but then employers opted to provide this. So, how are they supposed to be compensated? The compensation for this is that those who work or render work from home will be compensated as if they're working company premises. So let's go to the next slide. Article 84 of the Labor Code talks about the compensable working time. So all hours of the employee that the employee is required to give his employer regardless of whether such hours are spent in productive labor or involve physical or mental exertion. If the work performed is necessary or benefited the employer, the time during which the employer is inactive by reason of interruptions of this work, even waiting time that is not at the control of the employee is compensable. If one is made to go on standby, they remain, we call it on call. No? If you are on call and you are made to stay close to the premises of the employer, that he cannot actually go beyond, do what he wants, then that is compensable time. So employers cannot cite the reason, the absence of supervision, visual supervision as a ground to reduce the salaries. They cannot also cite the reason for, not being able to have direct physical control over the job of the employee as a reason for him not to get paid or to get paid less for doing the same thing. If you make somebody work at home, that particular direction has to be it has to be in such a way that the compensation also that is usually received by the employee is also, due him. Now, question, can he be entitled to overtime? Yes, he can be entitled to overtime if it can be established that he rendered hours of work beyond the usual work hours, and that the rendition of such service was actually approved and benefited the employer. Now, can the salaries or wages of employees be reduced? Under the law, it cannot be. So let's go to the next slide, please. Cannot reduce salaries and benefits without violating the rule against diminution, which is under Article 100. So in this case, reduction can only be done if it is agreed by the employer and the union, or if the employer is authorized by law to make certain deductions under Article 113 of the Labor Code. But then again, Section 5 of Labor Advisory number 17, series of 2020, the DOLE allowed the reduction of wages and entitlements of workers under certain conditions. One, as allowed by the department by DOLE issuances, employee and employer can voluntarily agree to reduce, agree to the reduction or adjustment. The reduction or adjustment will not exceed 6 months, as might be provided by the CBA, and that the reduction or adjustment may be subject to renewal by the parties. Again, the adjustments or the reduction in entitlements of workers can be done provided workers agree to it. It is something that has to be mutual. It is something that has to be, we call this, accepted by both sides as a win-win solution. Again, there is no obligation on the part of the employer to provide work, nor to pay the employee during quarantine, whether it is home quarantine or ECQ or any kind of quarantine for that matter. But then again, if an employer so provides an employee certain assistance or certain job activities to do, can he tell the employee that, because we are, in a dire situation, and just receive like a little bit less than what you used to receive? That can be done, my friends, provided these three requirements are met. So in the end, the issue of reduction of the issue of entitlement of wages really relies on what your CBA provides, what your company policy provides, and what your practices provides, insofar as situations similar to what we are in right now. Because the law does not give you anything more than the labor standards provide. Meaning, if you work during the pandemic, you get something. But if you don't work during that quarantine period, then you're not entitled to receive it. The last slide that I've shown, something that maybe gives us an idea of how to approach this thing. it has to be something that has to be the solution to this problem is really how to marry the requirements of the employer and the needs of the employees and the situation that both are in, such that there has to be understanding, there has to be agreement, there has to be what they call this mutual acceptance of each and every party's needs and also the situation that they are in. So it's not just even the reduction that is being that although it is a Department of Labor's idea to allow such reduction in wages or entitlements of workers, but then we can even go beyond that. So this would be my last slide. Can you please show it? If you've read the news the past few days, there was this news feed about Makati Diamond Residences that offered offered lunch pack for 4 to 6 people for about 2,500 pesos. 7 courses, if I'm not mistaken. That is unheard of in terms of pricing. Just imagine a high-end establishment, a hotel for that matter, offering 2,500 7 courses good for 4 to 6 people for lunch. That is unheard of. But then again, this hotel is actually doing it to save the employment of its workers, of its chefs. Why? Because since there is no more traffic so far as hotels are concerned, they don't have anyone to serve, so they're not. People are getting laid off, if not being under no work, no pay situation. They're on temporary layoff situation, maybe. So the hotel thought of an idea that these people can just get something out of the name of the company. So what they did was the cost of the food and the cost of the labor is what is being paid by the customers so far as the 2,500 is concerned. So there is no profit there in so far as the hotel is concerned. It's just purely quote unquote at cost reimbursement, at cost because of the cost of food, at cost because of the salaries and wages of the hotel workers that are affected. So in closing, while there is no real what they call this entitlement that can be given to workers, unless of course provided under things that I've mentioned, what is present or what is quite glaring is the possibility that workers and the management of the enterprises can work together to help each other. So with that, I'd like to end my presentation and give the floor to Attorney John and the panelists. Thank you.
So maybe I'll just have a few comments and then I'll turn it over to the rest of our panel. Attorney Noel, you mentioned Article 1711 of the Civil Code. So indeed, it's possible for an employee or the heirs of an employee to go after the employer in case of illness or injury. But as you correctly mentioned, there might be a need to show that the illness or injury arose from the employment relationship, and that might be a challenge. I think we should also take note that there may be limitations on such right to recover aside from that, because, for instance, the labor code states that the liability of the state insurance fund, now the employees' compensation and state insurance fund, shall be in place of all other liabilities of the employer to the employee, dependents, or anyone entitled to receive damages on behalf of the employee. I think the purpose for our social security contributions and EC contributions is that in case of work-related injury or illness, then the employee will certainly be able to recover through the employee's compensation and state insurance fund. But of course, nothing prevents the employee or his heirs to go after the employer in case of negligence. In fact, in a 1987 case, the case of Ismael Maritime Corporation versus Avellino, this involves the heirs of an employee who sought compensation for the employee's death from the first from the Workplace Compensation Commission, and then they filed a complaint for damages against the employer. So, what was the ruling of the Supreme Court? According to the Supreme Court, the employee or his heirs have a choice. They either seek to recover benefits from the Workplace Compensation Commission or sue for damages based on the employer's negligence. However, the Supreme Court said once the option is made, so for instance, the employee has chosen to recover under the ECC, then the employee or his heirs can no longer opt for the other remedy. So in short, the employee cannot pursue both actions. Well, assuming that the employee decides to go after the employer and not after the employee's compensation and state insurance fund, as correctly mentioned by Attorney Noel, it might be a challenge because one, you need to establish the employer's negligence. So maybe you can show this because of the employer's failure to comply with the Dole DTI interim and supplemental guidelines regarding safeguards for the prevention of COVID-19, for instance. And you need to show that the employee was infected in the course of employment. So you need to show established proximate cause. That might be quite difficult considering that before going to the place of work, the employee might have been exposed also to other COVID-19 positive employees outside the workplace. Also, well, the Attorney Noel mentioned the concept of no work, no pay. But of course, the Department of Labor, notwithstanding that principle, is also encouraging employers to either provide sick leave benefits, medical insurance coverage, and also supplemental pay allowance. But again, this is not a requirement. This is just the Dole encouraging employers if they can afford to do so. So those are my comments. I'll turn it over to Attorney Randall.
Yes, hello. Good afternoon to everyone. Can you hear me?
Yes, go ahead, Attorney Randall.
Okay, yeah. So first of all, I'd like to thank Attorney Noel for that very informative presentation. I think he covered most of the principles involved, no? Especially now we are in a pandemic. I guess my only addition to the presentation of Attorney Noel is this. We understand that we are all in this situation where we never foresaw it or even imagine it to be have happened in our country. But nonetheless, even if we are in what we call extraordinary circumstances, our legal principles and labor laws remain. So if you have any doubts or questions pertaining to whether this is legal or not, you just have to remember these legal principles. Like, for example, no work, no pay. So if the employee doesn't work on a particular day because there's a lockdown of your building or because the employee cannot go to work because there's no transportation, then unfortunately the principle applies. No work, no pay. And as well as the other uh, compensation, no? For example, the 8-hour law and overtime. No? But what this pandemic may have recognized are certain flexibilities. As you may have noticed in Attorney Noel's presentation, the law now allows certain reduction in the minimum standards of compensation. So if as before, you need to be paid for the entire 8 hours that you have worked because you are now on a work from home arrangement, it is now possible that both you and your employer may come into an agreement as to how you will be compensated. Or in the extreme measure, so that you will not all of you will be dismissed from employment, you are now allowed to negotiate with the company to retain all of you, but of course on a reduced pay. No? So all of this are the flexibilities now being recognized to address the perhaps the injustice or the absurdity if we apply our basic principles during this time of pandemic. But then the bottom line we always have to remember is that what we have right now, the legal principles and labor laws, they are still in force. They still remain the same. No, what the guidelines that have been issued by the Department of Labor is just simply to recognize that we can have some sort of flexibility, especially as regards to hours of work and terms of payment. Okay, so that is all for my comment on Attorney Noel's presentation.
Thank you, Attorney Randall. Very good points. How about you, Mr. Antos? Maybe you can provide your comments on the presentation of Attorney Noel.
Yeah, Attorney Noel really covered a lot of important topics and a lot of legal advice. And clearly, I'm not a lawyer like Attorney Randall or Attorney Noel. So what I wanted to add in terms of my comments was really around how you as professionals need to be able to adopt this regulations and communicate this effectively to the people that work for you. So that it comes across and everybody reaches that good situation balance that Attorney Noel talked about. And so three items. We conducted some research in the Asia Pacific region, part of the ADP Research Institute in January, called Workforce View 2020, and basically surveyed your employees. So the Southeast Asia data from that really showed that there's a couple of key things that employees are looking from you when you communicate with them. Given that work from home is unnatural, this is different, as Attorney Noel said, this isn't a full remote working setup. These are people that are not used to being at home, but need to conduct work at home. And so one of the things that they really requested is a clarity of expectations. So what are they supposed to be doing? What are the times that they're supposed to be there, and really setting that forward. And what we found when we came back and did additional research later in the pandemic period in June was that actually 28% of the firms in Southeast Asia had written policies in January to go home and work from there and what the expectations would be. That increased to 53%. So everybody seems to really be picking that up and being much more clear to their employees about what it means to go home. And so what we found from that, what they were really asking for, employees wanted to know what the pay rules are in specific situations. They wanted to know what their work expectations are. So what is you as a manager, if I don't see you all the time, what are your expectations of me? And then what's most important is how you train your managers to communicate this. So we found 18% of employees reported that they were feeling kind of judged by being at home. Am I really working or not? Or 13% felt guilty. Really only a quarter of them felt fully empowered to do the jobs that we need them to do, whether they're at home or going into the workplace. And so the second piece of this is now people that either can't go in, can't work from home, or people that come back, having companies have those same key ideals around how do we come back to work. And so again, written formal policies, well communicated, and manager training. What we did here to learn how this is working out was we went and studied in China in June and found out that employees there, 41% of them reported feeling uncertainty or pressure from management where it wasn't well communicated early in the pandemic as to whether or not they were supposed to be in the office or at home. 27% felt pressure all the way through, like maybe you should be in the office, maybe you shouldn't. And this creates an added level of stress, and it also makes the kind of calculation of payroll and the following of the rules quite a bit difficult. And now 13%, an additional 13% said that they didn't feel any pressure at the beginning, but now that China is reopening, they're starting to feel pressure, like if you're not ready, you need to be back in the office. So as you navigate what's right for your company and you're trying to follow the regulations, that idea of really written formal policies, being well communicated, and the managers that are doing that communication being well trained is critical for your success. And the reason, of course, for all of this is really because pay matters, right? For everybody on this call and for all the people that work for all of us, we all like to get paid, and we all like to get paid correctly. And we already knew before all this started that really only 2 in 5 people receive necessarily their pay on time. In Asia Pacific, about 29% were receiving incorrect pay. So they're busy kind of checking that. And we also know that people are working a lot of extra hours, especially at home, right? So there's this kind of mix of home and in the office. And we saw that as being over 8 hours across Southeast Asia in January. And that's actually gone up during the pandemic to 9.5 hours. So to me, today's discussion is super important because it's the application of this is really going to be able to create, whether we're working at home, we're half, or we're back in the office, success, for all of your organization. Thank you.
Thank you, Mr. Antos, for balancing the discussion of legal principles with your practical insights. Now we have a few minutes to answer questions from the audience. I start with the question from Ms. Marie Eloise Autor. She's asking if the employee cannot demand for compensation because there is no work to be done, can they be subjected to the dual employer law if they, I think the question is whether they can seek employment elsewhere while there's no work from their primary employer?
I'd like to take that question, Attorney John. There's really no prohibition against any prohibition against multiple employer. What is prohibited is actually what we call is conflict of interest, such that even most companies would like that their employees would not engage in activities that is directly in conflict with the work that they're rendering to the company. Then again, in this particular case, the issue is whether you can seek employment somewhere else in the meantime that there is no work given you. I think there's no prohibition in that regard.
Thank you, Attorney Noel. Of course, there might be some instances for managerial employees who might have provisions in their contracts against dual employment, but as a general rule, as mentioned by Attorney Noel, then there's no prohibition. Our next question is from Bin Munsod. What about those construction workers placed in barracks? If they are quarantined within the site or barracks, should they be paid during the quarantine period? Attorney Randall, do you want to answer that? I'm not sure if it's Attorney Randall was low internet connection or if it's me, but I cannot hear Attorney Randall. Or...
Yeah. Sorry. Yeah. Nag-freeze yung aking connection.
Ako din meron problema yung internet connection these days. I'm not sure if you heard Attorney Randall. The question is whether, for instance, construction workers who are placed in the barracks, if they are quarantined within the site or barracks, should they be still paid during the quarantine?
Yes. As I mentioned a while ago, because the basic principle is no work, no pay. So if they're not working during the time of quarantine, then they don't get paid. So it's now really up to the construction company to provide them allowances to get them by because they were, for example, not allowed to leave the barracks because of the quarantine measures. So that's an example where basic principles of labor still apply. You just have to make some certain flexibility in order to make sure that employees won't go hungry.
Thank you, Attorney Randall. And I think Attorney Noel also mentioned earlier in his presentation, the general rules on compensable time. I don't think this is a case of the employees being required to remain on call in the employer's premises. This is just out of necessity because of the quarantine.
Yeah, and at the same time, Attorney John, we have to remember that the barracks provided in construction companies or even in remote work areas is actually just a facility provided by the company so that the employees would not have any problem reporting for work, but it's not really to mean that if they stay there, they get paid.
Okay, thank you. I think there's a related question, Attorney Noel. In Article 84 of the Labor Code, what is the lawful computation of wage for waiting time?
Well, if you take a look at the provision of law, no, you are supposed to be at work. If you are supposed to be on waiting, on standby, on call, at the mercy of your employer, the beck and call of your employer, then you are supposed to be fully paid. In some cases where the employer would not like to pay in full, they would actually give the employee certain allowance for a quote unquote standby, or they call it standby allowance, just so the employee would be will be available if in case needed, and be given sufficient time to report to office and so on and so forth. But then again, what the law says is if and when all of those things, even if there's interruption, even if there is waiting time, there is standby time, provided that, you know, it is because of the nature of the job or because of the insistence of the employer, then it has to be paid in full.
Thank you, Attorney Noel. Yeah, I think the key here is whether the waiting time really is the integral part of the work of the employee, and whether the employee can effectively and gainfully use the time for his own purpose. So if not, then that's really compensable work. The next question is from Ms. Gina Evangelista. What if the employee does not agree with the reduction of compensation? If they are working only 3 times a week, are we allowed to pay only a certain amount because they are not working for a full week?
Okay. Colonel Randall, you might want to answer that one.
Well, as I mentioned, our basic labor laws still apply, and so you're supposed to be paid for the work that you do, no? But then the law, again, as I said, the Department of Labor recognizes certain flexibilities, and one of the flexibility that the DOLE recognize is where both the company and the employee agree on a reduction in of pay. Now, if the employee does not agree, then you are forcing your company to take extreme measures, because if they cannot find ways to be flexible under the situation, then they will have to resort to, redundancy or retrenchment. No? So I think it would not be beneficial if the employee would be demanding that he still receive the same pay given the current economic situation. Both the Department of Labor encourages flexibility not only on the part of the company but also on the part of the employee. So I hope the employees would also see that if they do not do their part, the company will have no choice but to do the extreme measures here in this case. Now, the other question is whether if he only works for 3 days, can he be paid only for 3 days? Yes, following the principle of no work, no pay. So what you do for work, then you get paid for that.
Okay, thank you, Attorney Randall. Next question, still related to reduction of wages. Uh, if the memo states that the reduction in salary is made effective upon receipt of this memorandum, will this constitute as mutual agreement? Parang automatic pala ito upon receipt of the document.
Automatic na.
I think that cannot be done because the law is very clear. No? Even if we don't have the guidance of the Department of Labor here, it has to be a contract has to be assented to by both parties expressly. It cannot be assumed that there is acceptance on the part of one party simply because it remains silent, uh, particularly in situations like this. So I would say that the employee cannot demand, the employer cannot just say that effectively the salary is reduced upon receipt. If and when he wants to reduce the salary or the wage, then he has to enter worker, the workers' representative, which is the union. Otherwise, as what Attorney Randall said, there are other options available. You can put people on, on reduced work week. You can put them on even on a temporary layoff or even permanent layoff by reason of retrenchment.
I think we're suffering from technical issues again. No? We've lost the audio of Attorney Noel.
Oh,
At least
Yes.
natapos naman yata niya yung questions just in time. So siguro, Attorney Randall, you should answer this next question. In a
Okay.
work-from-home setup, are employees entitled pay for interrupted unworked hours due to technical issues? What does it mean to say that such issues are beyond their control? So, for instance, in the scenario of the employee reporting for work, but then there's an internet outage, or if the employee had to log out for 1 hour in the middle of their shift to fix technical issues from their end.
Um, you know, this work from home arrangement is actually a new thing for all of us. We are not designed for this. In fact, Mr. John Santos mentioned that the best practice here is really to come up with a expectations on how you will go about work from home arrangement. That being said, if there is a interconnectivity problem brought about by power outage or there's a break in your internet connection, and the time that you are made to wait for that internet connection to come in may not be the same as waiting inside the company premises or offices. No, so this is not something that you can say you're not going to be paid for this, because after all, you're at home and you can actually do anything else while waiting for the connection to come in, right? This is unlike work where you have nothing else to do in the office but really wait it out. So my answer to this is that it, it it depends on how long you are going to wait for the connection to come in, and if it is too long, then you will not be compensated for that. But if it's for a short duration, then that could probably still be considered as compensable waiting time.
Okay. Uh, the next question is from Mel Season. I think this question has already been addressed. The question is, if the employee is under quarantine due to COVID, can the employer put them under no work, no pay if all the leaves have been used? So as discussed earlier by Attorney Noel, well, the dole has been encouraging employers to place the employees to allow the employees to use up their paid leave benefits. But if these are exhausted, then the general rule is that employees are on no work, no pay. Unless, of course, the employer can afford to do so, then the dole is encouraging. The word is encouraging. It's not really a requirement. If they can afford to do so, to maybe give some special allowance or pay to the employees. But there is really no such legal requirement. Next question. Say our employees live in the same unit and the one of them has COVID-19 or symptoms of COVID-19, and both are not able or advised to go to work. Should they both still be paid, or is it no work, no pay? Parang buy one, take one yata to, dalawang employees daw.
I think the rule again is the idea is no work, no pay. Remember, guys, that you have social welfare benefits like SSS, ECC, Pag-ibig, and then PhilHealth. Now, insofar as medical as the obligation of the employer to provide benefits while one is under quarantine or probably sick, if he has actually paid in full all of the social welfare benefits in your favor, he has no obligation anymore under the law unless provided under CBA or under employment agreements or policies or practices. He has no other obligation towards us, towards the employee. Why? Because essentially the social welfare benefits are there to back up the employer in times when the employee gets sick, the employee is unable to render work or is capacitated for whether for work related or non-work related reasons. So in this particular case, he can use the 5 days incentive leave If not, then he goes on leave without pay. But then again, SSS is there, which will answer the portion of the quarantine or health for because he's a suspect, he can file for a what do you call this? A sickness benefit under SSS. And if it can be established that it is work-related, you can even file for compensation under the ECC. Worst case scenario, if he's not able to go back to work after undergoing COVID quarantine, he can actually get unemployment insurance from the SSS also. So these things are actually all in place. Only that, of course, we would like also some share coming from the employer. But then again, it's not only us, it's not only the employees who are suffering this time, but more so the employers. So we have to balance off and be considerate in our asking for consideration from others.
Okay. Well, our next question is a sort of a variation. Can the company mandate an employee to use available leave credits to continue to get salaries even while on quarantine and no work is rendered? Parang ito naman yata ay gumamit ng paid leave credits yung employee. Baka may balak pa magbakasyon ng end of the year. The employee is still optimistic. Or she will be able to use up the paid leave. So siguro ayaw niya munang gamitin yon. But can the company mandate that the employee use the leave credits?
Ako, in my part, if it is covered by the policy of the company in terms of if the person is sick, then he has to use his sick leave to get paid. If the person is not is sick and he doesn't use his sick leave, it may be possible if he does not report his sickness and doesn't ask the employer for medical benefits. But then again, usually we ask for medical benefits from our employers if you get sick. So therefore, the employer can rightfully ask you to file your sick leave. Now, if for instance, the employer would say, oh, you go on 15 days vacation leave, go on 15 days work without pay. Someone says, I can go 1 month without pay. That is optional. So, wala namang, there's nothing that is attached to it so far as other benefits are concerned. So, I think the employer cannot rightfully impose the availment of sick leave, vacation leave in this case. But insofar as availment of sick leave benefits, it can rightfully impose or require the employee to consume the sick leave benefits because there might be attendant medical costs that are part of the medical benefits of the employee if and when he is on sick leave.
Okay. I think one concern here, or maybe one rationale why this issue comes up, because for instance, there are some policies providing for cash conversion of unused leaves at the end of the year. So some employees might not be willing to use up their leaves because they might think that they're unable to use them. Well, hindi nasusulit yung leaves, for instance, because they'll just stay at home. But I think the one justification for the employer too is that the employer, the use of the leaves is also a management prerogative. So you can perhaps schedule the vacation leaves or the use of the paid leaves to coincide with the period, for instance, when the employee is on quarantine. So I think there might be arguments for both sides on whether leave credits may be used up or utilized when the employee is not reporting to work or while on quarantine. I think we have time for around 2 more questions. Next question is, what if one of the employees of the company is positive for COVID, can the company file for sickness benefits with the ECC?
Yeah, I think he can. He can.
Attorney Noel, I think you have slow internet connection. Can you try again?
Yeah, I think he can file for SSS sickness benefits if he gets COVID-19. I think the maximum benefit period allowed is 30 days.
Okay. And then last question. Well, actually, we have more questions. So what we'll do, we'll ask Ms. Sarah and the PMAP staff to collate all the other questions, and then maybe we'll try to answer them. And we'll refer to those persons who asked those questions after the webinar. So our last question: in the event that the virus was established to have been contracted inside the workplace based on contact tracing, is the employer liable to full hospitalization expenses that may be incurred?
Hmm.
Like to answer that, Attorney Randall, would you like that to be answered by me?
You can answer it first, Attorney Noel.
I think the very reason why there is that COVID mitigation measures required by the Department of Labor, and the reason why Department of Labor is undertaking inspections on all establishments to determine their compliance to these COVID mitigation measures, in particular the ATF interim guidelines. That is because to ensure that the workplace it's not a place for the transmission of the virus. It will not become sort of the habitat for the virus uh, to stay. Now, people can say that yes, they contracted the disease from somebody who got infected, or they got infected from inside the premises of the company because they got in contact with this person. But then again, that is not perfect science, my friends. That is not perfect science. In the end, even if we say that that you were beside somebody who was positive, it doesn't necessarily mean that you get outrightly, what do you call this, infected by the virus. That is why if the company has provided all these mitigation measures, this is already sufficient compliance for the company to be able to come out clean from being accused of the party liable for the contraction of a particular virus by the. That's my opinion in that particular case.
In
Just to
fact,
add,
go ahead, Attorney Randall.
sorry, go ahead. Sige. Just to add to Attorney Noel, no, that's correct because the employer is not the guarantor of safety in the workplace. As long as he meets the minimum requirements, they will not be held liable for such an incident because, as you know, the virus is everywhere. You really cannot prevent it. But what may probably be, let's say, contributory negligence, if there's some sort of a contributory negligence on the part of the company, such that they do not observe minimum health standards in the workplace, then probably it may have some contributory, it can contribute to the damages that may have been suffered by the employee who contracted the virus,
Okay, thank you, Attorney
but
Randall.
not all. Yeah.
And also, you should also take note even the supplemental guidelines of the DTI. They simply encourage or highly encourage employers, for instance, to provide medical insurance coverage for employees. But this is a recognition, I think, that there is really no legal requirement unless, as you mentioned, Attorney Randall, Attorney Noel, it can be shown that the employer, for instance, failed to implement the proper safeguards and was guilty of negligence and be held liable for damages based on tort or quasi-delict, the provisions of the Civil Code on negligence which might give rise to damages. So I think that's it for the questions. Sorry, we have no more time. Maybe next time we can address all those questions. Maybe just a few more words from the members per panel. We can start with Mr. Antos.
Yeah, I wanted to thank everybody for their insight, because the one thing I've learned in listening to Attorney Noel and Attorney Randall is this is a changing situation, and every day is bringing new challenges and trying to understand this in new ways. So everybody, please stay safe, and thanks for joining today.
Thank you, Mr. Antos. Attorney Randall.
Yeah, thank you everyone for joining us in this short webinar. I hope that during this short span of time, we are able to at least address some of your basic queries. I know there will be a lot of you having a lot of questions. Perhaps PMAP can have another round of this webinar. That's all. Thank you.
Okay, thank you, Attorney Randall. And then Attorney Noel.
Yeah, thank you so much for spending time with us this afternoon. And As what Attorney Randall said, sa uulitin. We'll see you again, guys.
So I've been asked to summarize, so just maybe this as a short summary, given that we don't have time anymore. Well, as mentioned by Attorney Noel earlier in his presentation, even during a pandemic, no, the employer has a prerogative to require employees to report to work. In fact, there is a mention of overtime work during national emergencies under the labor code. But of course, the employer should also implement the proper safeguards to prevent COVID-19 infection in the workplace. Now, as part of the prerogative to report to work, the employer has also the prerogative whether to allow the employees to work from home. So the employees cannot really insist that just because they're afraid to go out, that they should compel the employer to allow them to work from home. Even under the Telecommuting Act, telecommuting arrangements or work from home arrangements are subject to the agreement between the parties. Now, assuming that the employee is allowed to report to work, then what are the entitlements? So the same rule applies even without a pandemic. Then the employee should generally be entitled to the same salaries and benefits in accordance with law. The employee cannot ask for more. Of course, the employer can voluntarily give maybe some hazard allowance or additional pay, but this is not really a legal entitlement of the employees. On the other hand, the employer also cannot just simply reduce the salaries and benefits of the employees, but subject to certain exceptions when otherwise allowed by law, or as discussed by earlier by Attorney Noel, when there is an agreement between the parties. So I think that, again, the agreement is crucial. In these times, there are legal obligations or legal rights between the parties, but maybe for everyone to be able to overcome this crisis, it will require some form of compromise between both the employer and the employee. So that's it. We thank everyone for their active participation in this afternoon's webinar. We hope that this session was helpful. For more webinars, please don't forget to subscribe to PMAP's YouTube channel and to follow PMAP's social media accounts. Again, a big thank you to our guests, Attorney Noel Balsicas, Attorney Randall Tabayoyong, Mr. John Antos, to our IR committee members, to ED Rene Hener, President Loy, and of course to our PMAP community and everyone who was tuned in this afternoon. Maraming salamat po. Stay safe, everyone.
Stay safe.
Global payroll. It's anything but simple. As an HR manager, it can mean high costs, wasted labor, limited access to data, and the risk of non-compliance, as well as dealing with multiple payroll providers and technologies. This adds up to a big waste of time and money better spent elsewhere. That's where ADP Celergo comes in. It's the all-in-one global payroll solution for mid-sized companies with one system of record, one integrated HR connection, one centralized point of contact. ADP Celergo is a unified cloud-based solution that combines global payroll with local expertise, offering assistance in up to 140 countries, including on-the-ground specialists to provide local regulatory compliance advice, and a diverse team representing more than 45 languages. Accuracy for records and reporting, with access to consolidated data across all countries. Reliability for data that's protected, secure, and compliant with financial standards across the globe. And efficiency for payroll that's on time, cost-effective, and under control. All overseen by your own dedicated account manager, providing high-quality support for all your payroll needs. ADP Celergo Global Payroll gives you more time to focus on growing your business because we take care of the rest. ADP Celergo, unified payroll for businesses across the globe.